Okay, we're reading section 8, actually, about sex offenses of the criminal law BARBRI outline. On page 59 is where we left off crimes against nature. We'll also talk about adultery and fornication and seduction or carnal knowledge, as well as bigamy. An early 1533 English statute made sodomy, a generic term encompassing many different acts, a felony, so that it became part of the American common law of crime. However, because of recent court decisions, it is unlikely that a defendant could be successfully prosecuted for most of these crimes if the act was consensual. Bestiality, which is the carnal copulation with an animal by a human being, is probably the only crime that survives. Okay. And adultery and fornication. Adultery and fornication were not common law crimes in England, but were punished by the church as ecclesiastical offenses. Got it. Sorry, I forgot how to say that. Sorry, I've never read the word before out loud. They are made misdemeanor offenses by statute in some states. Adultery. Under modern statutes, any person who cohabits or has sexual intercourse with another, not his spouse, commits the misdemeanor offense of adultery if the behavior is open and notorious, and the person is married and the other person involved in such intercourse is not his spouse. Or C, the person is not married and knows the other person in such intercourse is married. So fornication. Fornication is sexual intercourse between or open and notorious cohabitation by unmarried person. Incest. Incest is a statutory offense, usually a felony, that consists of either marriage or a sexual act, intercourse, or deviant sexual conduct between persons who are too closely related. 1, degree of relationship. 2, degree of responsibility. No uniformity exists between the states. A majority restricts the crime to blood relations, although a significant number of states include some non-blood relatives. And degree of responsibility, some states make a distinction in penalties depending on the parties involved. F, seduction or carnal knowledge. A statutory felony in many states. The crime of seduction is committed when a male person induces an unmarried female, a previously chaste character, to engage in an act of intercourse on promise of marriage. The MPC includes a section on seduction. It requires only that there be a false promise of marriage and does not require chastity or that the female be unmarried. In many states, subsequent marriage of the parties is a defense, but there is no uniformity as to whether the marriage must be entered into before indictment, after sentence, or anywhere in between. Bigamy is a traditional strict liability offense that consists of marrying someone while having another living spouse. In common law, a defendant is guilty of bigamy, even if she reasonably believes that a purported divorce is valid or that her spouse is dead. I feel like there's a 7-year statute of limitations there, but I'm not making up facts today. Okay, property offenses, section 9 of criminal law in this outline. This section deals with a number of property offenses. Many of these offenses have been consolidated into state theft statutes, but for purposes of this examination, the greatest challenge is in distinguishing among 3 property crimes: larceny, embezzlement, and false pretenses. There is no difference among the intents required for these 3 crimes. The major differences among these crimes are in the kind of misappropriation of the property. So we're going to talk about larceny, embezzlement, false pretenses. Before we talk about burglary, We're also going to talk about robbery, forgery, extortion, receipt of stolen property. All of these before we go into the offenses against the habitation, which includes burglary and arson. Okay, so we're on page 61. We got about 15 more pages to go. 17. Let's get into larceny. Larceny was the basic common law property offense. It has been significantly modified by statute in many American jurisdictions. Larceny consists of a taking and carrying away. Taking, caption is what's said here, and carrying away, which is asportation, said here, of tangible personal property of another by trespass, and with the intent to permanently or for an unreasonable time deprive the person of his interest in the property. So, 1. Under A, larceny. Property that may be subject of larceny. Larceny can be committed only by the acquisition of personal property capable of being possessed and of some value. A, realty and severed material. Realty and its fixtures are not subjects of larceny. If something is severed from the realty and taken before it comes into possession of the landowner as personal property, larceny is not committed. If, however, the landowner gains possession of the severed material as personalty, a subsequent taking of it is larceny. Example, A went onto the land by B and cut down 15 trees. She loaded 10 into her truck and drove off. B came onto the land, found the remaining 5 trees, and placed them in his shed. A returned and took them. Is A guilty of larceny of 15, 10, 5, or no trees? Held. A is guilty of larceny of the 5 trees that came into B's possession after their severance from the realty. Okay, B, services. Traditionally, obtaining services wrongfully cannot give rise to larceny. Interesting. Intangibles. Intangibles cannot give rise to larceny. Example, a wrongfully obtained entrance to B's theater and observes A, comma, miss the comma here, wrongfully obtains entrance to B's theater and observes a performance of a play. Has A committed larceny of that performance? No. The right or ability to observe a play is intangible. Note that gas and electricity are considered to be personal property that may be stolen. D, documents and instruments. Documents and instruments were, at common law, regarded as merged with the matter they represented. Thus, unless they had monetary value in themselves, they could not be the subject of larceny. A takes a deed to certain realty and a contract for sale of cattle from B's desk. Is A guilty of larceny? Held. No. The deed merged with the realty and the contract merged with the intangible contract right. Thus, there was no larceny. So there's that word merge. I'm not going to try to make that make sense under the quote-unquote merger doctrine that I'm still trying to define. But the deed merged with the realty, and the contract merged with the intangible contract right. Modern statutes have expanded larceny to include written instruments embodying intangible rights. Property of another. Can we say that's a blank checkbook? I mean, they're not giving me any examples. Anyway, property of another. Larceny is a crime against property. All that is necessary is that the property be taken from someone who has a possessory interest superior to that of the defendant. A, requirement that taking be from one with possession. The property must be taken from someone with possession other than the defendant. If the defendant had possession at the time of the taking, for example, defendant is a bailee of the property, the resulting offense is not larceny, although it may be embezzlement. However, if the defendant has custody rather than possession, her misappropriation of the property is larceny. 1. Custody versus possession. Possession involves much greater scope of authority to deal with the property than does custody. A. while in a store, asks B, the clerk, if she may take a certain suit of clothing home on approval. B consents. A then asks to see a watch to examine it. B gives it to her. A then absconds with both items. Have either of them been taken from B's possession? Held. The watch was taken from B's possession because A had only the authority to look at it. The suit, on the other hand, was in A's possession at the time it was misappropriated because of the extent of control B had given A over it. Employees. Low-level employees generally have only custody of their employer's property. They have possession, however, if the employer gives them especially broad powers over it, or if the property is given directly to them by a third person without the employer having intermediate possession. Like, there's a delivery of cash to the bank, and the branch manager accepts the delivery without recording it, in which case possession, intermediate possession, without employer having intermediate possession. Bailee and breaking bulk. Generally, a bailee has possession. If, however, she opens closed containers in which the property has been placed by the bailer, i.e. she breaks bulk, the possession is regarded by use of a fiction as returning to the bailer. If a bailee misappropriates property after breaking bulk, she takes it from the possession of the bailer and is guilty of larceny if she has the intent to steal. B. Possession at the time of the taking. And this is B under property of another. In determining whether someone has committed larceny, it is important to determine who had lawful possession of the property in question at the time of the taking. If a person has lawful possession when she takes the property, she is not guilty of larceny, even if she does not own the property, but she may be guilty of embezzlement. By contrast, a person can be guilty of larceny for taking her own property if someone else had lawful possession at the time the owner takes it. Example, A owns 2 cars but only uses one of them. She decides, therefore, to lease the unused car to B for 1 year. 6 months into 1 year lease, A decides she wants the car back. When B refuses to rescind the lease, A sneaks into B's driveway and drives the car away using her extra key. A is guilty of larceny even though she is the owner of the car, since B had lawful possession of the vehicle when A took it. Stolen property. Stolen property can be the subject of larceny. Example, a second thief is guilty of larceny when he takes property from a first thief. Joint property. A common law larceny could not be committed by the taking of jointly held property by one of the joint owners. E. Lost, mislaid, and abandoned property. Lost or mislaid property is regarded as constructively in the possession of the owner, and thus if it is found and taken, it is taken from his possession and larceny might be committed. Abandoned property, however, has no owner and larceny cannot be committed by appropriating it. 3, which we're still discussing the elements of larceny. In doing, we talked about property that may be subject of larceny, right? Because element 3 was tangible personal property. 2, we discussed the property being of another, which was the 4th element of the definition of larceny. And now 3, we're talking about the first element, which is the taking. It is essential that the defendant actually obtain control of the property. A. Destruction or movement is not sufficient, and B. Sufficient if caused to occur by an innocent agent. And it is essential that the defendant actually obtain control of the property. A. Destruction or movement is not sufficient. Mere destruction or movement of the property is not sufficient to constitute a taking. D. Knocked a glass from B's hand. It fell and broke. Is D guilty of larceny? No. Although X may have lost possession, D never obtained control. A damage to the item is irrelevant. Sufficient if caused to occur by innocent agent. Even if a defendant obtains control of the property through the act of an innocent agent, it is a taking. Example, D, pointing out a cow in a nearby field, offers to sell it to X for $10. X gives D the money and then takes the cow. In fact, the cow belonged to Y. Is D guilty of larceny of the cow? Yes. She obtained control of it by virtue of X, an innocent agent of hers. Asportation. 4, which is the second element of the definition of larceny, and carrying away, asportation. So, rather than give their example, I'm just going to say if she didn't actually take the cow, she walked away and just knew that the cow was going to stay there, but it was going to be in her title, then she hasn't actually asportated the cow. Larceny requires asportation. This is the definition. Example, that all parts or portions of the property be moved, and that this movement, which need only be slight, be part of the carrying away process. I will read the example. A came upon 2 upside-down wheelbarrows in B's yard. She turned them both right side up and moved 1 6 inches towards the gate. Was she guilty of larceny of 1, 2, or no wheelbarrows? Guilty of larceny of 1. Merely turning the wheelbarrow over is not part of the carrying away movement. Thus, it is not asportation, but merely moving the other wheelbarrow a short distance is enough, because that movement is part of carrying it away. Okay, there's so many other elements of definition that aren't met there. Did she take it? Did she carry it away? Is it tangible personal property of another by trespass? And is it with the intent to permanently or for an unreasonable time deprive the owner of his interest in the property? I would be able to argue that. That's all I have to say. I will be your defense, lady. Lady A. Alright, taking must be trespassory. The defendant must take the property from the custody or possession of another in a trespassory manner. Example, without the consent of the person in custody or possession of the property. A, taking by consent induced by misrepresentations. Larceny by trick. If the victim consents to the defendant's taking custody or possession of the property, but this consent has been induced by a misrepresentation, the consent is not valid. The resulting larceny is often called larceny by trick. A major difficulty is in distinguishing larceny by trick from false pretenses. State of mind required. 6. Intent to permanently deprive. And 7 is going to be specialized application of larceny doctrine. And after that, we're going to go into embezzlement. So, state of mind required, intent to permanently deprive. Generally, larceny requires that at the time of the taking, the defendant must have intent to permanently deprive the person from whom the property is taken of his interest in the property. The intent has to exist at the moment of the taking of the property. A. Sufficient intent. Intent to create substantial risk of loss, and 2. Intent to pledge goods or sell them to owner. So, if the defendant intends to deal with the property in a manner that involves a substantial risk of loss, this is sufficient for larceny. And 2. Intent to pledge goods or sell them to owner. It is larceny to take goods with the intent to sell them back to the owner or to pledge them, because this involves the substantial equivalent of permanent loss or a high risk of permanent loss. B. Insufficient intent. Intent to borrow and intent to obtain repayment of debt. Let's leave it at that. Possibly sufficient. Intent to pay for property and claim reward. This possibly sufficient intent. Okay, specialized application of larceny doctrine. There are several situations in which the application of the requirements for larceny is highly technical. That is for abandoned or lost property, misdelivered property, and container situations, as well as continuing trespass situations. Let's read these. Abandoned or lost property. Property abandoned by its owner, i.e., discarded with the intent of giving up all rights in it, cannot be subject of larceny. One who finds property that has merely been lost by its owner can, however, commit larceny of it. Two requirements exist. One, the finder must know or have reason to believe that she can find out the identity of the owner, and two, the finder must, at the moment she takes possession of the lost property, have the intent necessary for larceny. If the finder takes custody of the lost property without the intent to steal, but later formulates this intent, she has not committed larceny, nor has she committed embezzlement, since no trust relationship between the finder and the owner has been created. B. Misdelivered property. One to whom property is delivered by mistake may, by accepting the property, commit larceny of it. Two requirements must be met. The recipient must, at the time of the misdelivery, realize the mistake that is being made, and two, the recipient must, at the time she accepts the delivery, have the intent required for larceny. C. Container situations. Issue is whether defendant already has possession. One subcategory of misdelivery cases presents special problems. The container cases, in which the defendant is charged with larceny of an item that she discovers within another item after she has legitimately taken possession of the larger item or the container from the victim. The difficult question is whether, at the time she appropriates the item, does she already have possession? If so, larceny is not committed because the property is not taken from the possession of another. 2. Larceny may depend on whether parties intend to transfer a container. One solution to this problem is to distinguish among cases according to whether or not the parties intended the original transfer to be the transfer of a container, example, the item containing other items. If the parties intended to transfer a container, the recipient is regarded as taking immediate possession of both the container and its contents. Her later misappropriation of the contents is not larceny, because it occurs at a time when she already has possession. If, however, both parties did not intend to transfer a container, but rather regarded the items transferred as empty or otherwise not involving a transfer of contained items, the recipient does not obtain possession of the contents until she discovers them. If at the time she discovers and appropriates them, she has the intent to steal, she is guilty of larceny. And D. Continuing trespass situations. A trespasser taking a property without the intent required for larceny is not, of course, larceny. However, if a defendant takes property with a wrongful state of mind, but without the intent to steal, and later, while still in possession of it, forms the intent to steal it, the trespass involved in the initial wrongful taking is regarded as continuing, and the defendant is guilty of larceny. This doctrine has no application if the defendant's initial taking of the property, although trespassory, was not motivated by a wrongful state of mind. A took X's umbrella from X's possession without X's permission, intending to use the umbrella and return it the next day. The next morning, when A woke up, she examined the umbrella carefully and decided to keep it. Is A guilty of larceny of the umbrella? Yes. The larceny took place when A formed the intent to steal it. Since her initial possession was wrongful, the trespass continued until she formed the intent to steal. On the other hand, A had taken X's umbrella by mistake and later decided to keep it after discovering her mistake. The doctrine would not apply because her initial taking was done with an innocent state of mind. Embezzlement. B. Page 66.